We'll call this meeting to order. And the first item on the agenda is Carrie Richter. And I don't know how to bring your presentation up onto my screen. I see it's on that one, but
Good evening, Chair Basinger and Historic Review Board members. I've met most of you. My name is Carrie Richter. I am the Deputy City Attorney. I work for a law firm called Bateman Seidel, and my firm employs Bill Kabeisman and myself. I have been working with the city for a long time, more than 10 years, more than 10 years, less than 20 years. I don't know how many of you know this, but I have a master's degree in historic preservation. And I was a member of the Portland Landmarks Commission for 8 years and the chair of the Portland Landmarks Commission for 2 years. So I have a real soft spot in my heart for historic preservation, and I understand the work that you do, and it is very difficult work, and you deserve all kinds of warm, fuzzy hugs for this work, because it's difficult, and I I acknowledge that because I've done it. But my job this evening, we're going to spend about a half an hour, 40 minutes, talking about the process of reviewing land use applications that come before you. I'm going to give you some sort of, I hope, tips and ideas for how to review applications and sort of the things that I look for in reviewing them to sort of focus your thinking as you sort of open a staff report for the first time and go, geez, or, you know, you get some comments from people and you go, geez, I had no idea, you know, so how to sort of think about this and how to frame the issue. So there are a bunch of legal limitations on decision-making. So we're gonna jump right in with sort of the legal limitations on decision-making, right? And your job primarily is to sit as a judge, right? There is an application for a certificate of appropriateness before you to decide whether it should be approved or not, and you are the judge, right? You have to decide if the criteria are satisfied. You know, in every hearing, we have the disclosures. I don't know in HRB hearings whether or not Christina reads them or the chair reads them, but we have those disclosures that tell people what the process is going to be. And that's the process that is going to be you judging an application. So there are parameters under which you can judge, right? And so we have the federal ones, the United States Constitution, the United States Code. The United States Code is what contains the National Register standards. The National Register program is a program that is provided by federal law. And if buildings qualify for the National Register, then they come with certain guarantees that are provided by federal law. And that program has very little to do with what we do in reviewing a certificate of appropriateness. So we've got the National Register program. I mean, we do review applications for new construction in national historic districts, right? We review applications to alter buildings that are on the National Register, but that is by virtue of the local regulations and not by federal law, okay? Not by the National Register program itself. The next level of legal limitations we have are state limitations, the Constitution and the Oregon Revised Statutes. The next level of legal limitations we have in decision makings come from agency rules, and Department of Land Conservation Development and the Land Conservation Development Commission promulgate 19 statewide land use goals. The one you're most familiar with probably is Goal 5. Goal 5 protects historic resources as well as a bunch of other livability objectives like wetlands, like streams, like view sheds, and historic preservation is one of those goals. DLCD promulgates administrative rules that implement those goals. There are administrative rules that implement Goal 5 with regard to historic preservation. When that rule was first adopted, it required local governments to go and inventory historic resources. And Oregon City did inventory its historic resources and periodically updates those inventories. Those rules required that once you had identified and inventoried resources, you had to evaluate whether or not you wanted to preserve them, protect them, and we use the term designate them. So Oregon City designated certain resources. They designated individual resources and they designated historic districts. Some districts are designated by virtue of them being on the National Register. Other buildings are designated by bringing in a conservation district. The Kanema Conservation District, for example, is not a National Register.
McLaughlin.
Oh, McLaughlin, excuse me. Kanema is a historic district.
National Register.
Okay, sorry. McLaughlin is a local historic district, conservation district, which is a local designation. That distinction doesn't make much difference in terms of reviewing applications. Because when we review applications, we are reviewing them against what is this fourth level of decision-making, which is the Oregon City Comprehensive Plan and the Municipal Code. So once the Oregon City had identified all of these resources, right? They've inventoried them, they've evaluated which ones they're going to designate, and they have designated them. Once they are designated, then the question becomes, we've got to protect them, right? And we protect them by requiring a certificate of appropriateness when development is proposed. You propose an addition to an existing designated resource. You want to alter an existing resource. You want to build a new structure within a historic district. All of those things require a certificate of appropriateness in order to protect these identified resources. Okay, so in a way, when we're doing a certificate, we're reviewing a certificate of appropriateness for new construction or an addition or an alteration, we are reviewing them against the Oregon City Municipal Code, Chapter 1740. We're not reviewing them against Goal 5. We've already done that Goal 5 work. That Goal 5 work is a planning endeavor where we go out and inventory, and the city periodically does update their inventory and brings the inventory to you and potentially designates new resources. That's where Goal 5 comes into play. But with regard to the certificate of appropriateness for new construction, Goal 5 has nothing to do with it because we've already done that inventory work. We've decided what we're designated. The question is, are we protecting it? Are we preserving it enough with the proposal? Okay, there's a couple of different types of land use reviews in Oregon City. I'm not going to go through all of them because only one is relevant to the work you do, and these are Type 3 reviews. Type 3 reviews come before you because they require discretionary review, and we want to provide a public hearing, a public forum where the citizens have an opportunity to explain to you why they think an application should be approved or denied. This is unlike other types of decisions that are, say, clear and objective. For example, if an application is filed for a building permit and the building meets the height limitations and it meets for a residential building permit, it meets the height limitations, it meets the setbacks limitations, there's no hearing, right? These are ministerial approvals that the city issues regularly because there's no discretion. It's hard to imagine a more discretionary process than the one than the certificate of appropriateness questions that come before you. When you think about compatibility and you think about preservation and you think about adequate protection for resources and determining the character of the district, these are all things that require highly discretionary decision making, and that's why we do it in a public forum in a hearing. As you know, your decisions are appealable to the City Commission. If folks are unhappy with the decision that you make, the thing you need to know about those appeals is that they are on the record. That means that no new evidence can be submitted to the City Commission. That means that all of the evidence has to be fully vetted before you. And that's important because all folks need to have an opportunity to respond to the evidence that you receive. So if, let's say, you have particular expertise because of your training with finishes, and you know something about particular finishes, you need to disclose that particular expertise. If not at the beginning of the hearing, as it occurs to you during the hearing before the record closes. Because if your decision is going to rely on your particular expertise with finishes, the public needs to know that expertise and gets an opportunity to question you about that or to present evidence that may sway you differently as a result. Anybody want to ask me any questions or as we go
I
along?
have one question. The city commission review is de novo. What is de novo?
De novo is Latin for all new, like new. So in legislative decisions, which are different than the kind legislative decisions would be reviewing an inventory to decide whether to designate resources. In those cases, you make a recommendation to the city commission, and the city commission is like adopting new code, right? They're expanding a historic overlay, for example. And in those cases, their review is what we call de novo, meaning they can take new evidence too.
Oh, okay.
But in the case of quasi-judicial decision-making, which is the bread and butter of what you all do, those appeals are on the record. So it is really important that you are deliberate and thoughtful about the record, because the record you make is the record that everybody's stuck with going forward, good or bad, right? And so people come in to testify and they bring a sample of something. Your question needs to be, you want to put that in the record? Because if you take it out of the room, it's not in the record. And then you can't bring it to the city commission. So we need to be really specific. That's why we say during the disclosures, any oversized poster boards, difficult to duplicate documents need to be left here. As much as we hate storing awkward things, we need to store them because if that's the proof, right? You have to have proof that all of the standards are met. And if that's the proof, we got to have it in the record. So I talked a little bit about quasi-judicial versus legislative decision-making. The big difference here between these two types of decision-making is that quasi-judicial decisions, you are applying the criteria to the facts. You're not making the law. You are applying the criteria to the facts. The criteria are already set. You can't change the criteria. If the criteria say you have to use natural materials, then you have to use natural materials, or you have to interpret the term natural to mean something else, meaning it looks natural. But you can't change it to be a different standard. The criteria are the criteria, and you can't change them. You may not like them, but you're stuck with them. And the facts are the facts, right? The facts are what are presented to you during the hearing and in the record while the record is open. A key component of a quasi-judicial proceeding is that they get that the parties get an impartial tribunal, which means they get you reviewing an application not based on your personal view of the applicant, your personal thoughts about the historic district, your personal thoughts about preservation generally, but your best interpretation of the criteria and your very best understanding of the facts. If you cannot make a decision that is impartial, then you have to step down and not hear that matter. We'll talk about that a little bit further in a little bit. Decisions and quasi-judicial proceedings have to be made within 120 days. Staff can help you with that, but that's important for you to know that we can't keep these things dragging on and on and on and on and on. They have to be made within 120 days of when the application is complete, and that includes the review by the city commission. So if there's you know, 2 hearings before the HRB plus a hearing before the city commission, that can take 2 or 3 months. So we need to keep things moving along efficiently. Legislative decision making is the exact opposite from quasi-judicial. Legislative decision making, you're making policy. This is when you are adopting new components of a comprehensive plan. You are changing the language of the code. Like I said, adopting a new map to designate new resources. There's no legal formalities. Decision makers are expected to communicate with interested parties as part of making policy. And we talked about what de novo review is, and there's no decision-making timeline because we want to fully vet the decision. Okay, so we talked a little bit about the quasi-judicial hearing disclosures. In sum, those disclosures provide that a list of the applicable approval criteria will be provided, that a staff report is available, that testimony must be directed to the criteria, and this is one of those things that drives me crazy, is when you're sitting in a hearing and you've got all these people telling you what a good application it is. That is not, whether it's good or not, whether it's beautiful or not, that has nothing to do with whether or not the criteria are satisfied. The criteria relate to, like I said, preservation and protection of existing resources, and designing new construction that's compatible. It's from the 60,000 foot level. I understand it's much more complicated when you get down in the weeds, but requirement that you have to raise all issues before the Historic Review Board in order to raise them before the City Commission as well as to LUBA. LUBA is the Land Use Board of Appeals. That is the court that has exclusive jurisdiction over your decisions after they pass by the City Commission. An obligation to raise constitutional issues. The only constitutional issue that would come up, I think, in your review would be a takings issue. And so it probably doesn't come up very often. And then a right to an impartial tribunal. The impartial tribunal part is really critical, I think, for it's a critical requirement in order to have decision-making that is fair, and in order to have decision-making that evaluates the criteria based on what's written in our code. And part of providing an impartial tribunal is requiring that decisions be based on testimony and evidence that's part of the record. I talked about that a little bit, that you all are on this board because you have particular expertise with regard to historic resources. You all are out in the community and you are involved in the community with regard to historic resources, and that is to be applauded and not to be diminished. But we want to give folks an opportunity to know your experience and know what you are bringing to bear on an application in advance and have an opportunity to question you. So this includes ex parte contacts. Ex parte contacts are conversations that you could have with regard to a particular application outside of the public hearing process. So this is someone comes up to you at the market and says, hey, have you heard that this proposal is coming up, and I want to tell you a few thoughts that I have about it. And those conversations are not prohibited under state law. If you have a conversation like that, or if somebody comes up and approaches you and asks you questions about an application that you have before you, it doesn't mean you're disqualified. What it means is that you have an obligation to disclose the substance of that conversation in the public hearing so that folks have an opportunity to ask you questions to understand it better and learn more about what information you may have gotten from that conversation. So you are certainly free to have conversations about applications that are before you, but the longer those conversations are, or the more fact-specific those conversations are, the heavier the obligation is on you to disclose it during the hearing. So my general advice is when people come up to you and ask you something about an application that you have before you, you say, I'm sorry, but we have an application before us, and I encourage you to come to the hearing, and I'd love to hear all about your thoughts about it at the hearing. Ex parte contacts can come in the form of an actual meeting, like the way things happen in the olden days, or they can come electronically. They can come electronically in the form of an email directed to you, or they can come in the form of social media materials, chit chat, forums where folks talk about a lot of things, and sometimes you really reading along and they'll be talking about one thing, and then all of a sudden it jumps into an application that's before you. I mean, you sort of read the trail of the conversation, and then you realize, this is not what I thought this was going to be about, right? This concern about loss of trees all of a sudden turned into new construction in McLaughlin. You know, those chit-chat stories sometimes take on a life of their own. And so that is an ex parte contact. Even though nobody said, Chair Basinger, I want you to read this, you read it, it is an ex parte contact, and you need to disclose it. And because tracking these things can be difficult, I urge folks that as soon as these contacts happen, intentional or unintentional, I mean, again, you are in the world, you are an advocate for preservation, people expect you to be involved in these issues, send an email to staff and say, take a look at Chit Chat today, this came up. Or there's an article about this in this, or I got an email about this. Just for those materials, once you forward them to staff, we put them in the record, and then they're just in the record, and then everyone has an opportunity to talk about them, right? And 9 times out of 10, this stuff is irrelevant. But you are sitting as the judge. We have to control the evidence and provide people an opportunity to respond to all the evidence, irrelevant or not. The other part about this is that an impartial tribunal is that decisions have to be free of actual bias. An actual bias is a predisposition rendering it impossible to make a decision based on the evidence and argument presented. So there may be circumstances where you feel so strongly about something that you couldn't be impartial. For example, there are buildings in the city of Portland that I feel so strongly about that I couldn't have reviewed them because I felt so strongly about them. And again, that's a legitimate place to be. There are planning commissioners who felt so strongly about particular applications that they felt like they had to step down. But it's a personal decision that you need to make for yourself. The other part about bias or about impartial decision making is that you can't have an actual conflict of interest. And an actual conflict of interest occurs when a decision is like